The outcome of your individual case depends partly on what you do while the case is ongoing. While we're litigating your case in court, there are certain things that you must follow or do, certain instructions which we generally give our clients. The number one thing that you must do when we're litigating your lemon law or dealer fraud case is that you must continue making your monthly payments. If you fail to make your monthly payments, the financing institution will ultimately repossess your vehicle. Well, if they repossess your vehicle, they will have a claim against you for all the unpaid payments, and also they will ultimately sell your vehicle at an auction, likely for a much lower price than you agreed to pay for it, and then they will sue you for the deficiency. A lot of times clients are upset when they purchase a vehicle, and if the vehicle exhibits problems, if the problems are exhibited within the first month, they even refuse to make the first payment. Well, in California, there is what's called a first payment default. If you do not make your first payment, the bank has the right to repossess your vehicle. When that happens, you can rest assured that you will likely lose your down payment because the vehicle will be auctioned off for a much lower price, and then the deficiency will be claimed against you, and they will withhold your down payment and likely seek additional funds against you. The same thing will happen if you fail to make your payments a certain period of time into your lease or purchase. Let's say 3 months, 6 months later, you fail to make a few payments in a row. The vehicle will get repossessed and they will come after you for the difference. You will lose your down payment. Now, if you have an ongoing lemon law or dealer fraud case with our office while this happens, your case will still continue. However, your case will be drastically affected and it will hurt your case. This is why we always advise our clients from the first day you walk into our office, to continue making your payments so as not to breach your contract with the dealership or the manufacturer, so that you're the only one who has a legitimate claim against them. You don't want to open up the opportunity for the defense to have a claim against you. The other mistake that clients make frequently make is failing to keep the subject vehicle insured. If you are driving this vehicle and you don't insure it, if you happen to get into an accident, you will have to pay for the damages out of pocket, not to mention the fact that it's illegal to be driving without insurance. Now, even if you park the vehicle, and if it's not insured, if something happens to the vehicle, it gets damaged, again, you will have to pay for these repairs. If the vehicle gets stolen, you will not only have to pay for the loan, but the case will be so affected, negatively affected to the extent that you might lose the case. So it's highly recommended that you keep the vehicle insured to protect your case, to protect your claim, which involves the subject vehicle. Another event that happens a lot of times is when clients engage in what I call self-help measures. Clients at times will get creative. They will drop off the vehicle at the selling dealership and walk away. Well, legally, the vehicle is yours until the case is resolved. Therefore, if you walk into the dealership, park the vehicle, drop off the keys and walk away, that's the same as you parking the vehicle down the street, at the mall, or any other location within your town or city, and leaving the keys with some stranger and walking away. If something happens in terms of somebody uses your vehicle and some unfortunate incident happens, you will be legally responsible for it. Beyond that, you will still be responsible for the loan and the monthly payments should you leave your vehicle at the dealership. Therefore, merely dropping off the vehicle or giving up possession of the vehicle is not the same as a legal transfer of ownership and obligations. You must wait until your case is resolved through your attorney before you proceed and surrender the vehicle per your attorney's instructions. The last factor that I'd like to discuss, the thing that clients need to avoid, is taking actions without consulting their attorney. If you have a vehicle and the vehicle is in litigation, we're in litigation regarding the vehicle, should you experience problems, if the vehicle breaks down or exhibits certain issues which were not discussed at the time the case was taken on by our office or along the way, make sure you call our office before you take action. Call our office before you call the dealership or the manufacturer and complain about these additional problems, because there are certain ways that we handle situations like this, and there's certain procedures that need to be followed. We can't have you, the client, merely contact the manufacturer when we're in fact in litigation and they're represented by an attorney and you're represented by an attorney. The best thing to do is to keep us informed. We will direct you and guide you through the process of what you need to do to resolve an emergency that comes up, such as the car falling apart or breaking down unexpectedly while the case is in litigation.